Whitney Boan, a criminal defense attorney who has defended cases in both state and federal court, joins me now. Whitney, thank you for being with us with your expertise today.
Thank you, Harris.
Let's first talk about what a case looks like against this suspect now. I mean, you know, you've heard people say, well, the bombs didn't blow up. How much does that even play into the case that you build?
That's an excellent point. People have been very focused on the fact that these bombs didn't detonate, and even that maybe there's some evidence that is out there that he didn't intend for them to detonate, or they weren't even intended as destructive devices. However, the FBI has said that these devices were capable of exploding. What the distinction in terms of them blowing up or not is important is that these devices were sent, according to their theory, in terms of his trying to intimidate the recipients. And so the issue here isn't even necessarily in all of these counts whether or not this was an active bomb or a working bomb. He's charged with offenses even for just mailing a couple of these individuals pictures of themselves with red X's over their faces, you know, along with these devices. The issue here is intimidation, it's assault, it's not whether or not necessarily a bomb actually went off. Which would be different charges.
Oh, sure. Okay. Is this something that you would describe as a difficult or less than difficult case to prove as a prosecutor, since there is so much like physical evidence with these devices?
Well, there's alleged physical evidence. In other words, there's devices, obviously, that they've recovered. That's a foregone conclusion. But what I don't necessarily take as a foregone conclusion, because he's presumed innocent at this point, and we're just getting preliminary information, the investigation is ongoing, is that he sent these devices with the intent to intimidate anyone, or that he even necessarily is the one that sent them. I understand that there's been some preliminary latent print or fingerprint examination done in terms of one of the packages sent to Maxine Waters, and that package having something that they're saying resembled his fingerprint or that was his fingerprint. Those reports, it's not out of protocol, it's not out of the ordinary that we wouldn't know for sure or have like a full report about that at this point. But also that maybe he had DNA on a couple of the devices, or at least parts of one or two of them. So there's that, but I don't assume, absent having full reports, that they can necessarily prove it was him. It sounds very much like if you were the government, you've got a lot of great arguments in terms of these all went through Opelika in South Florida, which was the mail distribution center that he would have sent mail through. He had items in the van, allegedly, that were consistent with a printer that would have been used to print the labels and the return labels. So he had stamps that were similar to the American flag stamps, and he had some parts that were similar to the devices.
So there is evidence,
themselves.
but what you're saying is wait for it all to come in to see if it stacks up high enough to make this an easier case.
Sure.
I want to move on to the synagogue shooting suspect and the topic of the death penalty. The president weighed in on that. What do you say about it?
Well, I say that I would expect in this situation, we've already heard from the U.S. attorney in Pittsburgh that they intend to seek the death penalty relative to the federal case. There's a state case, and Pennsylvania hasn't done away with the death penalty. In other words, they haven't abolished it, but the governor hasn't allowed any executions to go forward for a couple years. So I guess you could say there's kind of a compromise situation there in terms of not abolishment, but not actually executing people. I think, however, in the federal case, based on the extreme nature of the motivation of these crimes and just the horrific nature of these individuals being at a place of worship, you know, and being elderly at that, ranging from 69 years of age to 97 years of age. There's police officers that were injured in this. There are very aggravating circumstances here that I think would motivate prosecutors to definitively try to seek the death penalty.
Whitney Boan, we will bring you back. Thank you very much for being with us today and talking through some of these topics with regard to two suspects today. Thank you.